Great. Good morning, everyone. Thank you for joining us on Privacy Day, and thank you again to the Academy, as always, for hosting us on our event today. Hopefully you take away some information you didn't know before and maybe reinforce some information that you did already know. This was meant to be an overview of where privacy came from, how the DIFC Data Protection Law 2020 came to pass, and what elements we tried to reinforce in it and why. And also talk a little bit about some frequently asked questions and updates for you about what's coming in 2021, not only in the DIFC, but what we understand to be coming in the UAE. And some of you may have heard some interesting news already about certain laws that are heading in the direction of data protection and security that will get us all running in the same direction, I think, at some point very soon. So with that, let's get started. Happy Privacy Day. Let's see if my slides move. There we go. Okay. So I'm just going to give a brief history or overview of data protection in DIFC and where we got officially our data protection law from effectively. So let's start with the 1980 OECD guidelines. These were globally recommended principles supporting fundamental human rights to privacy and a private life. So that's really where it all first was formalized by the OECD, which is an international body. It's not a UAE body particularly, but it does comprise members from all over the place, all over the world. And they fundamentally agreed in these guidelines eventually through the OECD what was important to cover off in terms of privacy and a private life. So this document, these guidelines still exist. They've been updated a few times, and they are the foundations of privacy law effectively. And then you skip ahead a few years to the EU Data Protection Directive. This was created in 1995. It's the first major data protection law. It was a directive. So that means in Europe, basically, when you have a directive, it's not a specific regulation requiring all of the member states of the European Union to comply in the same way. It was meant to be implemented into the various member states. They couldn't do anything less restrictive than in the directive, but they could be more restrictive. So that's why you might have heard, for example, that privacy regulation in Germany is a little bit more strict than in other places in Europe. You have the UK ICO, which is obviously now not part of Europe anymore, but at the time was considered strict, but not impractical, let's say. So they were quite pragmatic about their approach, whereas other regulators maybe were more theoretical and clinical about their approach. So that created a lot of discord, I think, within Europe and within privacy law in general. It basically, though, became the fundamental law that shaped what you saw up until last year as the DIFC Data Protection Law. So our 2007 law that was in existence until last year was based on the European directive. And you can imagine it's mainly because we are a common law jurisdiction. We follow and track the UK ICO very closely, and we wanted to make sure that whatever we did in terms of our law aligned with European law in particular, because of the fact that we had many organizations coming from those jurisdictions to get licensed here in the DIFC. We do apply other laws and principles, but with respect to data protection, this was the big one, and we jumped on that fairly quickly as well, following in the European lead. Okay, so as I said, you then had the DIFC Data Protection Law. It was first written actually in 2004 in some format, but it was revamped in a very, very broad and much more detailed way in 2007. The first administrator, actually, of the DIFC data protection law was the Dubai Financial Services Authority. So the DFSA actually was the first administrator of the law. And then in 2007, when our law was established, it was what became the longest standing one so far in the GCC, especially within this region. It was the very first one. It became a law that established the Office of the Commissioner of Data Protection and all of the powers of the commissioner, and became a much more formal sort of law. Then you see, for example, in 2011, the development of data protection law, and where we hear about this cookies law, for example, the e-privacy directive. It was updated to preserve privacy rights while you're online. So there was a lot of tracking and monitoring going on by what we know as cookies. And I say there, it's not Big Brother, it's you. If you don't pay attention to those banners that pop up, for example, about cookies, when you go to websites, and you'll see they're on a fair number of websites, not just European ones, and that's because these laws have extraterritorial reach. If you don't change your cookie settings to what you want them to be, then your cookies will track you. There's advertising cookies, there's analytics cookies, there are basic static cookies that are always there to be able to make sure that your session information is available, so you don't have to log in all the time. That's because of cookies. You can just go back to a page and it's there, or you can at least have it remember your information. That's because of cookies. The e-privacy directive also regulates advertising and direct marketing. So when you hear about being able to go on a do not call list or what have you, in Europe at least, for example, that's mainly because of this e-privacy directive. So it supplemented the European 1995 directive. But it's not Big Brother, it's you. You can set your cookies to whatever settings you like. You can do some research about it. There are some resources available on cookies and how they work. And you can make it so that you don't have as much interruption with respect to advertising or tracking or what have you. Then in 2016, we get the GDPR. There had been several drafts over the years in earnest since 2012, and then it was actually enacted in 2016. In 2018 is when it became enforceable. So Europe gave all of the companies and data controllers and processors and what have you in Europe 2 years to prepare for compliance with the GDPR. And that's when enforcement could begin through the regulators' offices. And we did something similar here, and I'll get to that in a moment. It requires effectively data controllers to be more transparent and accountable. It also requires processors to be very transparent and accountable now. It added some extra accountability requirements for processors as well, where there hadn't been any before. And it's a regulation now instead of a directive. So that means it is fundamentally the same law throughout Europe without as many derogations. There is room for European member states to derogate. And the UK, again, having left the European Union through Brexit, has exactly the same law effectively. And in fact, it's GDPR plus, some might argue, that there's some additional refinements that make it a much more sort of powerful safeguarding law for personal data. That's up for debate, but in any case, that was the intention. So we tracked that as well. And then in 2019 and 2020, we set to updating the DIFC data protection law from 2007. And we got there in the end with the law that was enacted on May 21st, 2020. It's been effective since July 1st, 2020, and it's been enforceable from October 1st, 2020. So we'll talk about that a little bit later. October 1st, though, was not a deadline, and you will hear that again and again from me and from other guidance that we've set out on the commissioner's webpage. It didn't sort of end with October 1st, meaning you had to be compliant by then. You always have to be compliant with the data protection law if you're working and processing data in the DIFC or processing DIFC data for another controller or processor in the DIFC. So for those registered and using the portal, you will want to keep your notification and your compliance up to date. And I'll go into that a little bit later, as I said. And I'll go into some of the updates, as I said, as well. So for 2021, will there be a UAE national law? Almost certainly. We'll touch on this at the end as well in a little bit more detail, but we are looking at probably seeing some sort of national law. It's inevitable. I mean, if you look around the region, you have other laws springing up in countries all around us. Saudi Arabia is building their law. Egypt enacted theirs earlier last year. Qatar has a data protection law. Bahrain has had a data protection law for a number of years as well. So it's inevitable that it will sweep through the Middle East and into Africa, and it's already quite an established sort of thing to have a data protection law in Asia, Latin America. The states are looking at doing a data protection law. So it's kind of inescapable, let's put it that way. and it's a good thing, really, in the end, because it's enabling business, really. I know a lot of people have this notion that data protection law stops sharing data and it means you're not allowed to do this or that. That's kind of the opposite of the intention, though. It's not meant to do that at all. What it's meant to do is to enable data sharing safely and ethically. You know, none of the laws say absolutely no. There are plenty of bases for sharing data, some of them quite broad, and we'll get into that as well. So we're going to talk about some of the key concepts in these data protection laws. Accountability. Who is accountable? What's it about? What does it mean? Applicability. Does data protection law really apply here in the Middle East? Yes, absolutely. Controllers and processors, who does what? Data subjects' rights. These are the highlighted ones that I'm going through now. What is a data subject's right? What are they and how are they ethically applied? Data transfers, where is the personal data going and what happens when it gets there? So let's talk about these things a little bit as we get into the nitty-gritty here about data protection on Privacy Day. So accountability is about being responsible for personal data that you collect as an entity and how you share it, who you share it with, how long you keep it, where it's stored, what kind of security measures you have around it, whether you have policies and education and registers of processors and things like that. And certainly whether you have a data protection officer or not. Under the DIFC data protection law, for example, data protection officers are mandatory for only two types of organizations, that is center bodies, and for entities that conduct high-risk processing, which you have to determine for yourself and then make a decision as to whether or not you appoint a data protection officer. It's obviously encouraged that you can appoint a data protection officer anyway. It helps add credit to your accountability position as a controller or processor. Applicability, data protection laws, as I said earlier, European law, for example, can have applicability here in the Middle East, as does the DIFC data protection law within the DIFC, as well as for processing or types of processing outside of the DIFC, if you're engaged in processing DIFC personal data. Controllers and processors, I've mentioned that once or twice. A controller is an entity that basically collects data and decides what to do with it. The processor is the entity that follows the controller's instructions. To put it very, very basically, that's what those two terms mean. And they have a lot of responsibility. They're the ones that need to be accountable. They're the ones that need to understand how to make sure that data is shared and processed in an ethical way. And I'll get into what ethical data sharing means later as well. Data subjects' rights. Data subjects are us, and we still have a right to manage our data, even though an organization has collected it and is processing it for a variety of reasons. And in some cases, we've handed it to them willingly to do so. We can still go back and say, hey, I'd like to update my data. I don't want you to process this particular data. I would like to have access to my data and see what it is that you have in your records about me. You can do all those things. These are data subjects, right? Just a few of them that I mentioned. And data transfers is a really big topic. We'll touch on a little bit later as well in more detail. Where is the personal data going. This is what drives the world now, technology. Just in the last year, we see with COVID, for example, everybody had to go online. That's a lot of personal data being shared in a lot of different ways, a lot more new ways that weren't shared before. How does everybody know what can and can't be done with that data, and what are the controllers and processors dealing with it, doing to make sure that it's not breached, to make sure that it's secure, that the right people get it, that you're, deleting information that you don't need anymore, all those kinds of things. So transferring of personal data has become a massive issue over the last year, especially with data shooting around everywhere on the world with online working that we've been doing. So just to show you a bit about the GDPR influence in data protection law, not just here, but elsewhere, if you look at other laws around us and throughout the rest of the world, it's really had a huge impact on what data protection laws look like. And these are the core principles in the GDPR, and they're just like the principles in the DIFC data protection law. You have to process data in a lawful, fair, and transparent manner. You have to process it in a way that's expected by the person whose data it is. Process just enough to do what you are doing. So data minimization, data accuracy. You can't, be processing inaccurate data. It's important to understand that the data you have is accurate, and if that means, updating it regularly or requesting updates, that's a possibility, as long as it's done lawfully and fairly, and then only kept as long as necessary and kept securely. These are some of the fundamental principles of data protections. There's a few more around, again, technical and organizational measures and security, and it's really important to apply these principles in your business. And it's not, again, a barrier to sharing data and just running your business, but what it is bearing in mind this culture that we should be building of privacy and of compliance, so that people are thinking before they hand out somebody's mobile number, for example, in a business context, or before they share a piece of personal data. They just don't know what's going to necessarily be done with it. So they need to make sure that they're following a certain type of etiquette or principles around that type of data processing. And these are the same things that you'll find in the DIFC data protection law. So how about a polling question, just to kind of break things up a little bit. So the first polling question is, which DIFC body was the first administrator of the DIFC data protection law in 2004? Is it A, it has always been the Commissioner of Data Protection, B, the DFSA, C, the Registrar of Companies, or D, there was no DIFC body enforcing the law until 2007? The poll is open. We'll give you about a minute to log your answers. Please go ahead and log your answers, everyone. I gave you the answer earlier. Hopefully you remember. Again, is it that it's always been the Commissioner of Data Protection, the DFSA, Registrar of Companies, or there was no body enforcing the law until 2007? How are we going, Maristella?
Hi, Lori. Currently, we have 50% votes, so we encourage the other 50% to please cast your votes now.
Okay.
Choose your answer. Okay.
I'll give you a few more seconds, everybody. Please cast your vote on the poll about who was the first administrator of the DIFC data protection law in 2004. That's kind of the key little hint there for you.
Okay, we now have 62%. Shall I close it now, Lori?
Sure. Thank you. Thanks, Maristella.
Thank you.
So how did we do? What was our result here? Oops, let me get my slideshow back up. Okay, good. So most of you did select the DFSA. That is the correct answer. It was the DFSA who first administered the DIFC data protection law in 2004. The Commissioner of Data Protection was established as a DIFC body in 2007, in the 2007 law, and that's where the powers of the commissioner were set out and the functions, and that's how we've been functioning ever since. And even in the DIFC Data Protection Law 2020 update, the commissioner's powers have remained largely the same. Okay, so just to give you a sort of side-by-side of the Data Protection Law 2007 versus the 2020 update, let's go have a look at that. Being a bit slow. Here's the overview of the law. This is exactly what you'll see if you go to our website, what the table of contents effectively of the law looks like. And you can see how it's broken down then as well. And it kind of makes sense when you look at it in terms of the parts of the law. So we have, starting with basically general requirements, that sets out the processing requirements for regular personal data, for special category personal data, which is the stuff that is extra sensitive that you want to handle in a different way because it might expose somebody unnecessarily to increased danger or risk. So race data or health data, especially in the time of COVID, you know, inaccurate health data being exposed unnecessarily might impact somebody very negatively. You know, people might not want them working for them, for example, or being able to leave the house when, you know, if it was correct information that was shared, they would be able to. So this actually has become quite a big issue as well in terms of health data. Also in terms of employment data, there are certain pieces of information that are quite sensitive that employers process, and again, especially in times of COVID, could really impact you know, your ability to continue working. So we set out that in part two under general requirements, and then we get into if you see part 2D, it gets into accountability issues like records of processing activities, designation of a DPO, doing data protection impact assessments, and other items that you see there that, and in fact, notification being one of the first ones, which we'll talk about later as well. Then we get into part 3, talking about the obligations of controllers and processors, what a joint controller is, and there's been some question about what that means versus being a co-controller. A joint controller situations where two entities get to decide together what the purpose of processing is, whereas a co-controller is implied in the definition of controller, and that you know, it's just another controller that you're sharing data with, but you're not necessarily working together with that controller to determine the outcome of the data. That co-controller gets to determine the outcome of their data that you've given them on your own, or on its own, I should say. Then you get into part 4, data export and sharing. That's talking about international transfers, as I was talking about before, and what the safeguards around sharing data internationally are required. Information provision, so what's important to share with data subjects. That's talking about your privacy notices or your online privacy policy, so that you give data subjects a heads up as to what happens with their data when they deal with your organization, because it's really impossible to share with everybody, you know, in the world what you're planning to do. You don't know who's going to access you and your services in advance, so that's what privacy notices do. Rights of data subjects is part 6, and we talk there about the right to access, rectify, or erase your data, which everybody has maybe heard of erasure as the right to be forgotten. Right to restriction of processing, to understanding data portability in terms of, you know, wanting to move from one provider to another, for example, and the requirements for data controller sharing that data so that you can change who you're dealing with, non-discrimination, methods of exercising data subjects' rights, etc. And then you talk about personal data breaches in part 7. Some cases you need to notify the commissioner. In all cases, effectively, if you decide to notify, you need to notify the commissioner, but in some cases you need to notify the data subject directly as well. Then we talk about the commissioner's powers and functions and remedies, liabilities, and sanctions. So if you feel as though somebody's contravening the law to your detriment, you can complain to the commissioner, you can lodge complaints, you can request mediation, and the commissioner can impose fines as well. Okay. So, sorry, my switching slides is a bit slow. There we go. So if you look at the side by side, you know, I put this in all of my presentations really just to remind everybody that, you know, I wanted to make sure people are not worried about having to change a whole lot fundamentally and the cost of compliance with the new law. You know, surprisingly, I have heard some people come back saying, you know, there's going to be additional burdens on them. And it just makes me think, well, were you maybe not compliant with the 2007 law or not as compliant as you thought you were, which is a good thing in the end. You know, we'll work with you, we'll help you understand through guidance. We can't give legal advice, obviously, but we can sort of say, well, this is what you already have in place. You know, it looks like you're in good shape there, or you can do a maturity assessment. There are tools out there that you can sort of see where you are with the law. But it wasn't intended to be a huge upheaval, and it wasn't intended at all to increase the cost of compliance. But if you weren't compliant in the first place, you will have some work to do. But you'll see all the same themes are there. Accountability is there, data subjects' rights, security breach reporting, international, it's all there. It's the same basic breakdown of the law. It's just that we introduced some additional requirements to help enhance your position. And really, in the end, because of the way European law or Asian law, Southeast Asian Pacific, sort of South Pacific law in New Zealand and in Australia, you get all sorts of laws that are coming forward that are similar to this. So getting compliant with our law will really help you be compliant with most of them as well. So it reduces your risk as a business, quite frankly, to be able to align with our law. Okay, and then just a bit of information about the objectives, powers, and functions of the commissioner. The commissioner is there to monitor, ensure, and enforce compliance with the law, but also to promote good practices and observance of the requirements of the law and promote greater awareness and public understanding. And that's what we're doing here. That's why we reach out so often to provide information. Because it's really important that we build that culture of compliance. And we can only do it by talking about these things and helping to understand where they come from. And, you know, we're always happy to the extent that we can, you know, to share information and help guide the companies and entities in the DIFC and the data subjects as well, so that they know what they can do and what their rights are. You know, sometimes we don't answer our emails right away because there's quite a lot of questions that come in from time to time, but we do our best to get back in touch with everybody and answer their questions in a timely manner. And, you know, where we need to dig in a little bit more, we do that as well. So please do reach out. Supervision and enforcement, as I said, there is unfortunately the downside of the powers and functions of the commissioner, which is to be able to issue fines. We don't love it, but it has to be done occasionally when there's just blatant non-compliance with the law. But we try to do supervision first. We try to help you understand, because, you know, a fine is just a smack on the hand sort of thing. Sometimes it's quite a large smack, but you don't learn anything from it, really. What you do learn is that if you breach the law, you get some sort of punitive you know, imposition on your business, but it doesn't really help you learn how to make your business really a much better, more compliant sort of business. And it's, again, best practice business. It's expected by your clients, by your customers, by the data subjects that you deal with. And it's really important to show them that you do consider these best practices and that you take data protection compliance seriously. Okay, so I'm going to ask another poll question here. We talked about it. The answer was given to you already. Hopefully you remember, as I said. But the key question here, the key word I should say, is enforceable. When did the DIFC data protection law actually become enforceable? It's already enforceable since July 1st. It was enforceable from November 30th, from October 1st, or October 30th. If you could open the poll now. Yep, there we go. Poll is open. We'll give you some time to answer this question. And meanwhile, it looks like we have a question from the audience. Not sure I understand the question from the audience, but we had a question about the date. So the date of the law is, or the reference to the law actually within the law is that it's the DP Law of 2020. And we're asking, when did it become enforceable? It already is enforceable, and it became enforceable sometime during 2020, so not in 2021. How are we doing, Maristella?
Currently, we have 65%. So
Okay,
shall
great.
we leave it for a few seconds? Yeah,
Give
okay.
it a few more seconds, and then we'll close it down. So maybe 10 more seconds.
Okay.
Great,
So please
thank you.
vote, cast your votes now.
Great. Let's go ahead, Maristella. What have we got?
Yes, we got 70% votes.
Okay, great. All right, good. And most of you got that one right. Yes, it was C. It's been enforceable since October 1st, 2020, which means basically that it was from that date that the commissioner's office could begin issuing fines for noncompliance, but it wasn't a deadline date for you to just get compliant by then and then sit back and not worry about it again. You have to maintain your compliance. If your processing changes, you have to update your notification. If you want to change your data protection officer name or appoint one at all because you didn't before, that would be something that you update your notification on as well. And it's not necessarily cumbersome. You know, it's just basically keeping tabs on, well, are we doing something different? Have we decided to collect a different type of data and process it for analytics now instead of, because we want to get a better idea of what our customer base looks like? That would be a change in processing that you probably should update and change your notification on. In the regulations, you have 14 days from the time that processing changes. We, of course, will never know unless there's a breach and we somehow find out. But in any case, it's important theoretically for you to keep that notification up to date. But the law has been enforceable since October 1st. Okay, so we're gonna move on. I realize we're about halfway through, so I wanna keep talking a bit about some of the themes in more detail that we mentioned earlier. Sorry about that. I'm not sure why my slideshow keeps jumping out of screen mode, but okay, there we go. Right, so in focus, we're going to talk about Articles 6 and 14. So Article 6 talks about applicability, Article 14 talks about accountability, and Article 6 says that it applies to all DIFC entities, not only financial services entities, and the law applies also to commercial permissions, even to companies that are winding down. I mean, any time that you're capable of collecting or processing personal data while you're a DIFC entity, the law applies. And also it applies to entities not incorporated in the DIFC, but that have stable arrangements. And we talk about stable arrangements below. It's effectively, in the EU, for example, this is where this concept comes from. It's any real and effective activity, even a minimal one, through stable arrangements. So a relationship, a gateway, or a platform for processing into this jurisdiction, okay? And the threshold for stable arrangements can be quite low. So in some cases, a single employer agent with a sufficient degree of stability of operations would satisfy that test. So we are, not necessarily in a position at this time to have had a situation where there's a question about stable arrangements and whether Article 6.3 applies, but it does apply, and you have to, or for now at least, until we have a case that tells us otherwise, you have to think about this in terms of your arrangements with non-DIFC entities, and making sure that you have them comply with the law as well in the context of your processing activity. Okay. And then we talk about the rest of the articles here. We talked about Article 14 a little bit already, but these are the accountability articles after Article 14. You talk a bit about, for example, the requirement under the Article 15 to maintain a written record of processing activities. So basically, you can keep a spreadsheet or template for a ROPA, as it's abbreviated to. You can just look that up online, even if you want to, and download a decent template for that, and just document, or effectively your accounts payable is kind of your record of processing activities, because these are the entities that you're dealing with in order to process personal data, and you can maintain it that way. Even look at who you're paying. Basically, your suppliers are probably a good place to start in terms of your ROPA. Article 16 is where you talk about appointing a DPO. I've touched on that already. You're not required to unless you engage in high-risk processing activities, and we have guidance for that, for both, actually, for appointing a DPO and what high-risk processing activities are. There are tasks required of the DPO that you see in detail in the remaining articles of that section. If you do appoint a DPO, in addition to updating your notification on an annual basis, you have to file an annual assessment, which is basically an annual data protection impact assessment. Okay. And then we talk about contracting requirements. Certain notes here that you need to pay attention to is that where certain requirements where AI is used, you have to pay attention to continuing to use in your cessation of processing policies or in your contracts. And then we talk in Article 29, I want to highlight that note there regarding emerging technology. There are special requirements around notifications to data subjects to make sure that they're aware that you use a certain type of technology. So those of you in the FinTech Hive, for example, you probably want to make note of this one so that if you do use particular emerging technology that impacts the way data subjects' data is collected and processed, and in fact can't be erased, for example, if they can't exercise their right to erasure, you need to let them know that in your privacy notice, and probably also a good place to do it would be in your contracts as well. And then we talk a bit about what data subjects' rights are and having the appropriate policies, and then Articles 41 and 42, as I said, around security breaches. So I just want to show you again, just as we refer back to the GDPR where this all came from, this running theme throughout our presentation here. Controllers must be accountable, must adopt privacy by design, must appoint a representative, if not in the EU. We don't necessarily have that specifically, but it may be something that we regulate on. Take care when using third parties, keep processing records, tell data subjects about breaches if you have to, etc. You can see here on the slide that there's a lot of sort of just basic best practice requirements that have been legislated for in the law, and that's the same as under our data protection law as well. Okay, I'm going to take a quick look before you open the polling question, Maristella, about some of the questions here. We'll get to the polling question in a second. Right, so we have a question from the audience. When would an organization be required to appoint a data protection officer? Would ensuring data protection clauses in contracts and technical measures to protect data be sufficient for compliance? So again, for appointing a data protection officer, you have to do an assessment of whether you conduct high-risk processing activities. There are specific guidelines around that, and it says so as well what that means in the law. And we have some tools and guidance available on our website that you can use to help you assess that. You know, just a very basic little survey actually that will take you through and help you come to a conclusion there. And the links for those are in this presentation. So that's the only time that it's mandatory to appoint a data protection officer. You can do if you like. And yeah, data protection clauses and contracts and technical measures to protect data is good for compliance. I don't think we can say it's sufficient. It's not the only thing. You have all those other requirements that I listed out under the accountability section in Articles 15, 19, 20, 23, 24, and having policies in place, for example, as well around data subjects' rights too. So we have in our guidance as well on our website a compliance checklist that you can download. It's in the presentations on our guidance page that say intro sessions. So most of those have that Excel spreadsheet. It's a compliance checklist, and you can download that. Right, so I am going to actually move on now to the polling question. So Maristella, if you can open the poll, please. And I'll take that opportunity while we're waiting for the poll to look at this other question. Okay, so polling question 3, to which entities does the DIFC data protection law apply? I went through this earlier. Is it any controller or processor incorporated or licensed in the DIFC? Is it any controller or processor outside DIFC engaged in stable arrangements? Is it C, only controllers licensed in the DIFC, or is it D, both A and B? Hopefully that's easy to answer.
So we currently have 42% of the audience votes now.
Okay, great. Thank you. Perfect. Give it a few more minutes. Really appreciate your questions as well. I'm hoping that we can end in time to ask some actual live questions, but we'll get there eventually.
Okay, now we have reached 70% of
okay, great. Let's close it.
Okay.
Thank you, Marisol.
Thank you.
All right, how did we do? Great, yes, both A and B. That is correct. A is correct, but it's also B. B is correct as well. Okay, good. Let's move on. Okay, so just a little bit more about accountability. Why is accountability important? It's about taking responsibility as an entity and organization for the very vital information, personal information that people are willingly share in order to be able to provide the services for them that you do. You know, if you look at big tech companies, for example, or social media, or, you know, any of our entities that have apps that enable how people work and live, you're providing those things for free, but really, in the end, you're benefiting in the sense that it's good advertising for you. You can advertise through it. You know, you do end up benefiting financially from somebody else's personal information. So it's about really taking care and protecting that personal information the way you would protect your own. We're all consumers and we all are sharing our data in some way or another. So it's really a key to keep in mind that, you know, that's just not an element or a line on a spreadsheet or something in a database. There's a person behind that information, and you really do need to be accountable to them, transparent with them about what you're doing with their personal data. Ethical data sharing, I've mentioned a few times throughout this. It's really important to get this concept in your head, is that, you know, it's not just about sending data here and there and processing it, as I said, for your commercial purposes. It's about doing it in a way that is virtuous, let's say, and keeps in mind that person that's at the heart of it. Really, you know, ask if you can share their data. It seems like maybe an extra step. It's not, it doesn't take very long though. And if somebody says no, you have to sort of live with that. You know, it's their right around their personal data to delegate how it's shared. under the GDPR and under the DIFC data protection law as well, again, drawing that comparison between the two, data subjects have the right to know what's going to be done with your data, copies, getting copies of everything that's being processed. And, there's some guidelines for that under or on our website. Having incorrect data corrected, having data erased, to restrict processing, to porting their data where they like, to object to data being processed, and to not being subject to automated processing. So bearing all these things in mind, that they are all reflected in the DIFC data protection law and the UK law, Australia law, Japan, Singapore, Philippines, Argentina, Brazil. I mean, these themes are throughout. You need to have policies in place to be able to deal with these things, whether you operate in one jurisdiction or whether you operate internationally. It's really, you have to have some sort of ability to respond to requests from data subjects, and a policy around that is key to making sure that you do it right and that you comply with the law. Okay. So here's some other issues to be mindful of. These are sort of frequently asked questions. Why are transfers to other jurisdictions such a hot topic? Where there is no data protection law and personal data goes to that jurisdiction, there's less likelihood of it being safeguarded in a way that it would be at home. And so it's really important to make sure that there are safeguards that you do have to apply within your originating jurisdiction, like DIFC or Europe or UK or wherever, is enforced by you through contracts and through additional safeguards like model clauses or what have you, and policies within your own organization on the other end, making sure that whoever you deal with is actually going to take it seriously and process data in a way that is safe and secure. And really, why as a business would you want to share data with an entity that doesn't do that? It causes more risk and liability to you, even without data protection law. There's going to be some sort of impact that data subjects would, not be happy with you for. So you get reputational damage, you could even be sued. So it's important to make sure that if you're sending data to a jurisdiction where there is no data protection law, or even where there is one and it's maybe not so secure or as well founded, you want to take precautionary measures around that. And you're indeed required to. And then you hear about Schrems and sending data to the US. You might, if you're paying attention to data protection developments, there have been these cases called Schrems 1 and Schrems 2 in Europe, which have invalidated arrangements with the US between the EU and US. This next one called Privacy Shield. The first one was called Safe Harbor, but the next one was called Privacy Shield. They've both been invalidated, and it's because there's this concept that once the data resides in the US, once it's transferred there, it may not be as safe or secure because of certain surveillance laws and so on. So that's an ongoing issue, and it's being resolved in Europe as we speak. In the DIFC, we've never recognized either Safe Harbor. Well, we did used to actually a long time ago recognize Safe Harbor, but we don't anymore, and it's obviously invalid anyway. We never recognized Privacy Shield because it's the arrangement between the US and the EU. It doesn't really necessarily apply to us anyway. But it could do if we had sent data to Europe and it was onward transferred to the US. But to send the data to Europe anyway, you would have been able to use another functionality within the DIFC, like model clauses or what have you. Okay, or getting a permission. We don't have permits anymore, though, for transfers of data under the data protection law here. Are companies considered data subjects? I think this was similar to one of the questions that was put through the chat. Companies are not normally considered to have personal data. In a few places in the world, the data protection laws have said that a company can have quote unquote personal data, but it is not that case here or in Europe and the UK or what have you. Okay, so it has to be a natural living individual. And if it's their data being processed in any way, shape, or form by your entity, then you have to apply the data protection law. Is consent required for processing? Not necessarily. We have extensive guidance on consent. And I think this is one of those myth areas that gets quite confused for people. Consent is not always required. In certain cases, sure, you can use it. It's really hard to maintain, but it's obviously one of the most bulletproof as well versions of being able to process data legitimately. But keeping up on consent, people change their minds, people decide not to consent anymore. It's very difficult. And if it's not in a marketing context, there are other bases on which you can process data that don't involve consent. There is no specific marketing law in the UAE yet. We'll talk about it in the next question, actually. It is coming. About direct marketing, we do have guidance now that will probably be updated with respect to how you can, as a business, market with respect to being a DIFC business and what you're allowed or not allowed to do. You do have to notify in your privacy policy about marketing. And there is a consumer protection law coming from the UAE level that will regulate marketing and advertising and require better safeguards around consumer data. So it's replacing a 2006 law. It will probably, we'll see an executive resolution in May 2021. And the implementation period will likely be 1 year. There's an article that you can read on this page that I've included at the bottom there. And then completing a notification in the portal. I want to get through this as well to be sure that you know how to do it. And we're coming up with some sort of more intuitive and helpful ways to complete your notification. But yeah, if you process personal data, you're required to notify under Article 14, right? So you go into the DIFC portal. If you're onboarding as a new entity, it's part of the process already. But if you're an existing entity, you do the notification service request. There's guidance throughout, and you can see there's a hyperlink to the notifications guidance as well. You ask yourself, for example, these questions while you're getting ready to notify. Do I undertake high-risk processing? Do I have to appoint a DPO? Where does the data I collect travel to? So you're going to answer some questions about that, what jurisdictions you send data to and whether they have safeguards in place. And if you don't know certain answers, that's okay. You can always say, no, you don't know, and explain why not. And in fact, we actually ask the question when you say no, well, why not? And it gives you an opportunity to explain that. And it opens up a dialogue with us if you'd like to talk about that a little bit more. You have to think about what would any people whose data I process reasonably expect me to do with that data or my company to do with that data. So you see, you would need a privacy notice or policy on your website and privacy contracts in your clauses. And I've noted the articles that you want to look into there as well. And again, notifications must be up to date in accordance with the regulations. October 1, I'll say it again, was not a deadline. It was the date from which we can enforce the law, but you need to keep your notifications up to date anyway. And as I said, here's some general resources that you can check about everything that we've said so far. So here's the last polling question. We have about 8 minutes left. I'm going to ask one more question of you guys. This is a kind of a different version of a previous one. Under DP Law 2020, when is the date for submitting a notification to the Commissioner's Office that my entity processes personal data? October 1, 2020, B, October 1, 2020, and every renewal date after that. C, there is no fixed date. It's within 14 days from the first known processing of personal data. Or D, none of the above. The poll is open. We're going to keep this one pretty brief. We were just talking about it. I'm going to look at one or two more questions while we're doing this.
Okay, so please cast your votes for the last polling question. We now have 10%. Lori, we'll keep it for the next 30 seconds, yeah?
Okay, great. Thanks, Maristella.
Thank you.
Excellent. And just as a reminder, these slides will be available on our website. The presentation is being recorded, so it will be posted as well on the DIFC YouTube channel, and you can always run through it again. You can share it with your friends as well, or your colleagues, I should say. All right. Okay. So when is the date for submitting notifications? Are we closing the poll?
Yes, 60%.
Great. Okay, perfect. Let's see. What did we get here in terms of our results? Great. Yes, there is no fixed date. It is within 14 days from the first known processing of personal data and any changes to processing thereafter. So absolutely glad you got that one right. We'll move on. It's probably going to do something weird to me again. Okay, great. Okay, so the future of data protection law in the DIFC and the UAE. In terms of the data protection law in the DIFC, we will only make amendments as necessary. We're going to make a few procedural sort of amendments already to the law. Every law sort of proves itself in terms of certain little tweaks that need to be made, but nothing that will fundamentally change anything for you guys, I think, for our controllers and processors in the DIFC. But we do plan to, help make compliance support a lot easier, make it more intuitive through the portal, with a kind of assistant we're trying to build that will help you when you're doing your service request for your notification or coming back in to do your notification renewal, help you understand without a lot of effort, what it is we're asking and why we're asking these questions about the data protection law and your compliance with it. And it helps you and your education with respect to the law as well. It's not just about ticking boxes or, making sure that you're just complying with the checklist. That does help, and that makes things a little bit easier to know that you've not missed anything, but you need to understand why it's so important. And that's what we really want to build here. And if you're a privacy professional listening to this call, please get in touch with the commissioner, commissioner at dp.difc.ae, which is provided in this presentation as well. And let us know if you'd like to join a group of professionals that are dealing in privacy here in the UAE. We have a way of sharing information and a LinkedIn group as well. We don't want advertising there. We purely want to make sure that it's for, keeping up to date on data protection, compliance, and privacy developments. We're going to be looking into increased but fair enforcement. So yes, fines happen. None of us really want them to, but it is a part of doing business, and sometimes we, misstep. We hope to only have to apply fines in a very sort of egregious, blatant non-compliance, or if you don't update or renew your notification. Please, 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 I'll say this really clearly, I hope, don't on your notifications choose that you don't process personal data simply to avoid paying the fee. We'll look at, reworking the fees and things like that, but the fee goes towards getting this kind of free guidance and information and support from the commissioner's office without having to, necessarily go to law firms that will maybe charge you a lot more. Now, it's important to go to them and seek legal advice because we can't give legal advice. We can just give guidance, but we are happy to help. But when you have really key specific questions, going and seeking legal advice is your best bet. I mean, there's a lot of knowledgeable privacy professionals in the DIFC and around the UAE now. It is a developing area, and this will help you avoid enforcement action if you engage a firm to assist you and support you. So definitely, it is important, but we will help you, and we do want you to understand what is key to the data protection law. Capacity building, we'll be sending some surveys and information sharing and feedback. We welcome feedback so that we can stretch our legs as a regulator and, become more active and supportive and helpful, and we can provide the guidance that makes sense to you, not just what we think is important. So your feedback is invaluable. Will there be a national UAE law? Again, most likely, it's very, very likely that there will be one. It's a developing area of law. And certainly in this region, Saudi recently published a draft regulations, Bahrain, Qatar, Egypt, Jordan is drafting a law. It's happening everywhere all around us. India, different parts of Central Asia, South Africa has a law as well. So definitely, start getting compliant. We have that consumer protection law that I mentioned as well. It is unavoidable. It's something else to comply with. We realize that, there's some compliance fatigue out there, but it's important that we do these things because, there are so many moving parts to a business these days, and especially with respect to digital life online. And we need to make sure as a community that, vital data isn't inadvertently shared, so that you have identity theft or other detrimental consequences with respect to processing personal data. So yes, you'll be seeing other laws like this develop. And really, again, as I said at the outset, it's about best practices. So you may as well jump on board. And that's it, everyone. Thank you so much. It's 10:59. So if there are any further questions, we should just check on the chat here. Yes, the slides will be shared with the attendees. Lena was saying that it doesn't have much on DP, the Consumer Protection Law, but it does have certain specific requirements around advertising, around marketing, around safeguards and data protection issues generally. So there are a lot of similarities, but yeah, it's definitely not a national data protection law by any stretch. It's a first step in hopefully the right direction. I don't know, we'll see how it plays out when we get the final thing published and enacted, and then we'll have to deal with that then. And we will be holding webinars to update you in that regard as well. But thank you for your comment, Lena. Lena Amalek is from Bird & Bird, one of the law firms that does deal with data protection, and yeah, very helpful feedback there. Thank you. Let's see, there was one more question I'm going to try to answer. Right. Oh, it's quite a long one though, so maybe we'll take it offline. Yeah, it's just about receiving queries from clients about certain data protection issues. Valentina, why don't you reach out separately to Commissioner at dp.difc.ae and look for these slides online on our guidance page and also through our social media channels. And that's it. I don't want to keep you any longer. I do wish you again a very happy Data Privacy Day, International Data Privacy Day. It's one day a year to kind of honor all of the work that's gone into making life online a safer place for all of us. And I do hope that you take away my comments as well in this webinar and apply them within your own businesses. Thank you so much, everyone. Have a great day and a nice weekend. Thanks, Maristella, for running this for us as well.
Thank you so much,
To the
Lori.
Academy.
Have a great day. Thank you.
All right, take care. Thanks, bye.